Welcome to this video, and today I thought I'd share some insights with you about contract reviews. Now, it's often the case that if you're a company, you'll often be sent a contract by a third party and they will say, this is our standard terms and conditions and please review this contract and ideally don't make any changes, sign it and return it, and then we have a deal. Now, when you receive that kind of contract, what do? You can read the contract and make some changes, make sure that the prices are right, etc. But there's a lot of legal content in there, and often people get concerned and say, well, what does all this legal language mean? And so they often send that contract to their lawyers, and their lawyers look at that contract and then often come back with a huge number of changes and say, well, you can't agree this clause because of this, or you can't agree that clause because that's too onerous, or X, Y, Z. So therefore the company gets this contract back from their lawyers, and essentially so many changes, and how can they present that to another party and say, well, our lawyers have said that your standard terms and conditions just don't work, and how is that process going to be managed? So here are my insights into contract reviews. When I look at a contract and people are looking for a review, the first question is, what are the bargaining positions of the parties? Now, if you're doing a deal with a major global company, the chances of them wanting to actually change a large majority of their contract just for you are going to be pretty low. So essentially making a huge number of changes to their contract, number one, isn't really going to go down that well, and number two, the chances are that you're not going to get all many of those changes agreed with this large global multinational. So you kind of have to understand the bargaining position of the parties when you're looking at this kind of contract. The second thing to understand if you're having your contract reviewed is what really matters to you from a commercial point of view. Now, often if you're a supplier, what really matters to you is that you get paid the right amount, you get paid on time, and also you have some reasonable remedies if you don't get paid. There might be some other things that you hold on to your IP, and that you don't sign up to some clauses which are way too onerous, that might be disproportionately onerous on you compared to the other party. But generally you should have an idea of what you really want out of that contract. And what is really useful is for you to share your ideas with the lawyer or your legal advisor to say, this is what really matters to us in the contract. The rest of the contract, we're not that concerned about. If there's anything really onerous in there, please tell us. But just make sure that these three things, let's say the price, the payment terms, and the remedies for not being paid are okay. Highlight any other major show-stopping clauses, but other than that, we're okay with it. And so therefore, at least you've given your lawyer or your legal advisors a steer as to exactly what you're looking for, rather than just saying, please review everything and give us a comment on every single clause. Because you know for sure, if you're dealing with a large multinational, that all of those comments are not going to be accepted by the large multinational. The other thing that I often say when I'm looking at these contracts is look at the practical aspects of this. You could end up negotiating the legals for days, months, even years in some cases. And essentially, if you're starting out, or if you're a medium-sized business that you actually need the contract and you need the revenue, then stalling the contracts on the legals just may not be viable. So therefore, for a lot of risk mitigation, you might look at practical ways of mitigating the risk by, for example, getting purchase orders from your customer before you provide any work, You might actually keep in regular contact with your customer to make sure that if there are any problems, those are sorted out, so there's no problem with payment, etc., etc. So therefore you might think around a lot of the legal provisions and actually hope to deal with those practically, so that therefore you don't have to debate them in the contract. And essentially what we found is that if you can keep a good rapport with your customer, if you're a supplier, then hopefully the contract will never need to be reverted to and read or enforced. And by the way, talking about that, it's really important to understand that even if you have a contract, trying to enforce that contract can become very expensive, can become very disruptive, so therefore you want to avoid that at all costs. So therefore keeping good communication with your customer is always a good practical measure to implement when doing contracts. So in sum, contract reviews, look at the bargaining positions of the parties, try to prioritise the comments, and also try to make sure that you can deal with some things practically, so even if they're not in the contract, you can actually deal with those on a day-to-day basis. I hope that that is useful in terms of some insights with regard to contract reviews, and if you have any queries, then please do contact me at jimmy@coachinglaw.com. I hope you can see and feel how excited we are about sharing this information about the legal world with you. We're really interested in what questions you might have for us, and so please do email in and we'll respond quickly to your email. Also, if you have any friends, family or businesses where you think the information on this site might be useful for them, then please do share a link to this free content with your friends, family or businesses so that they can benefit too.